Welcome everyone to the Relentless Hope studio. My name is Cindy Metcalf and I'm the Executive Director of Relentless Hope. We help those who have been trafficked and ritually abused. Alongside me is my wonderful husband and investigative researcher, Goel, from Investigations and Ritual Abuse. Most of you know him from his Substack of the same name. Goel has been working on pedophile cases for over 20 years. He will talk today about the details of the Mandy Bachman case. Mandy is a warrior for justice. She has uncovered alleged abuse that has taken place in Goshen, Utah, a small town 70 miles southwest of Salt Lake City. Mandy became aware of the abuse through family, friends, and clients. In her quest to save a young child, Mandy got herself into trouble with the law and landed herself in jail. Although she didn't act wisely in her pursuit for justice, we believe she is being treated unfairly by the Vernal Police Department and county jail officials where she is being held. Mandy's constitutional rights have been violated. She has been denied medical care, food, and a speedy trial. Whistleblowers, take heed. When you talk about abuse, you can find yourself the target of criminal and civil charges to keep you quiet. Goel and I first met Mandy over a year ago when she told us about a particular child abuse allegation made against the biological father. The mother, who is a friend of Mandy, made accusations of ritual abuse and rape. The child is under the age of 5. Goel and I were interested in her case because we had heard similar accusations from other survivors who had mentioned the same perpetrators. Allegedly past and present Goshen City councilmen have been involved in child trafficking and ritual abuse, according to the victims. The alleged perpetrators include Goshen City mayors, city employees, and LDS leaders. We had originally invited Kim Bachman, Buffy Snell, and Angie Martin to our studio to talk about the case. However, we've had technical issues, and so with our new equipment, therefore, Goel and I are going to give you a summary of what they presented. We're going to ask our guests to come back and re-record the session. We apologize for this situation. We did want to get the information out about the prayer vigil for Mandy Bachman. We will announce that at the end of this program.
All right, everybody, we're back, and this is Goel with Investigations and Ritual Abuse and Relentless Hope. With me is my wife, Cindy Metcalf, or Cindy Darcy, as I like to call her. In today's focus, we're going over the Mandy Bachman vigil on Tuesday, which will be on Tuesday at 10:30, Provo at the District Courthouse on Freedom Boulevard. And so we're going to go through a quick review of her case and why you should care and why you should attend the vigil. So, as I go through here, this is Mandy Bachman. Many of you know her as the founder of Square Peg Ranch, a nonprofit providing equine therapy. She's the mother of Caitlin Bachman and Lindsay Morell, both of whom figure prominently in her case. So on May 15, 2024, Caitlin Bachman, Beth Chardine, and Ty Wetton were charged with various crimes, including aggravated burglary and aggravated assault, as well as aggravated kidnapping. On August 19, 2024, things escalated and a warrant for the arrest of Amanda Bachman was issued on August 19, 2024. She was charged with 6 crimes: obstruction of justice, aggravated kidnapping, aggravated burglary, theft and extortion, impersonating a peace officer, and forgery. Now, for our purposes, we're going to be focusing on the aggravated kidnapping and aggravated burglary charges. And so, a little bit of a background: Derek and Lindsay Morell, who was Mandy Bachman's daughter, were married in 2017. Now, on July 9, 2023, Derek and Lindsay's divorce was finalized, at least as far as the decree went. The custody and the property issues were bifurcated into separate matters, quote, to be handled in due course. So bifurcation is basically where you finalize the divorce decree, that is, a couple is no longer married, but the issues of custody and property are bifurcated into separate matters, as it says, to be handled in due course. Now, by August 7th, 2023, the court had issued a bench warrant for Lindsay on the grounds that she had missed a court hearing and that she'd violated a court order regarding parent time, and she was to serve 15 days in jail. On November 3rd, 2023, Lindsay Morell's parent time was suspended indefinitely pending further order of the court, and Derek Morell was awarded sole custody of Piper Morell. According to Beth Chardine, Mandy Bachman planned and enlisted Chardine, Mandy's daughter Caitlin, and a man named Ty Wetton, who was a romantic interest of Beth Chardine, to travel to Vernal in order to kidnap Derek and Lindsay Morell's daughter Piper from Derek's custody. Now, Chardine has entered a plea agreement in which she testified against Mandy Bachman and her co-defendants. So what we have here is a divorce. We have a custody dispute. There were allegations of abuse made by Lindsay Morell and Mandy Bachman against Derek Morell as it pertained to Piper Morell, Lindsay and Derek's daughter. And so the elements of a crime, accessory in Utah, and this is very important to understand what Utah law actually says. So under the criminal code, section 76-2-202, criminal responsibility for direct commission of offense or for conduct of another. So this is the exact language of the statute. Every person acting with the mental state required for the commission of an offense, who directly commits the offense, who solicits, requests, commands, encourages, or intentionally aids another person to engage in the conduct which constitutes an offense, shall be criminally liable as a party for such conduct. So they have to have the mental state. They can solicit, request, command, encourage, or intentionally aid another person to engage in conduct which constitutes a criminal offense. They'll be just as criminally liable as the person who's actually committing the offense under Utah's law. So this is the aggravated burglary statute. Now, it depends on the burglary statute, which defines burglary as an actor commits burglary if an actor enters or remains unlawfully in a building or any portion of a building with intent to commit a felony, theft, assault on any person, lewdness, sexual battery, lewdness involving a child, or voyeurism. Now here's where it becomes aggravated burglary. An actor commits aggravated burglary if in attempting, committing, or fleeing from a burglary, the actor or another participant in the crime cause bodily injury to any person who is not a participant in the crime, they use or threaten the immediate use of a dangerous weapon against any person who is not a participant in the crime, or they attempt or possess to use any explosive or dangerous weapon. In this case, Ty Wetton, who was the male who traveled to Vernal with Beth Chardine and Caitlin Bachman, had a firearm. So that's a dangerous weapon. According to Wetton and Bachman, when they knocked on the door of Derek Morell's residence, the door opened and they entered. The question of why Wetton and Bachman were at Derek Morell's residence is key. Were they there to serve papers for mediation, which is what they initially claimed and what Amanda Bachman claimed? Or did they attempt or intend to use a forged court order, which is what law enforcement claims, to take custody of Piper Morell? If the latter is true, they were committing a felony, especially if Wetton was posing as a social worker, which is what law enforcement alleges. Ty Wetton was allegedly posing as a social worker and as a state employee with a forged court order in order to compel Derek Morell to turn over custody of Piper Morell. Now, the absurdity of that is somewhat obvious when you consider that Derek Morell would have known that Caitlin Bachman was Lindsay Bachman or Lindsay Morell's sister. So there's some issue there. Now, aggravated kidnapping is the next major felony charge in this case. It goes back to the regular kidnapping statute. An actor commits kidnapping if an actor intentionally or knowingly, without authority in law, and against the will of an individual, detains or restrains the individual for any substantial period of time, detains or restrains the individual in circumstances exposing the individual to risk of bodily injury, holds the individual in involuntary servitude, detains or restrains a minor without the consent of the minor's parent or legal guardian or the consent of a person acting in loco parentis, moves the individual any substantial distance or across a state line. Aggravated kidnapping. The aggravating factor means that in the course of committing an unlawful detention or kidnapping, they use or threaten to use a dangerous weapon. So Ty Wetton, as we said before, had a firearm on his person. The question of whether or not he intentionally or knowingly was attempting to kidnap Piper Morrell, that's a matter for the courts to decide. It's a matter of whether he intentionally or knowingly was engaged in that conduct. So did he believe that he was there to serve papers for a mediation, or did he believe that he was there with a forged court order to compel Derek Morrell to turn over custody of Piper Morrell to him, to Beth Chardine, and to Caitlin Bachman? So aggravated kidnapping includes the attempt to kidnap someone, but it also requires the intentional and knowing detention without authority of law of a minor, in this case Piper Morrell, without the consent of the minor's parent or legal guardian or the consent of a person acting in loco parentis. So did Ty Wetton present a forged court document while posing as a social worker? If so, he and anyone else who knew that the documents were forged and that he was unlawfully posing as a social worker is guilty of aggravated kidnapping due to his use of a dangerous weapon. If Mandy Bachman did in fact enlist Ty Wetton, Beth Chardine, and Caitlin Bachman to engage in the intentional and knowing detention of Piper Morrell under these circumstances, she is guilty under the accessory statute that we reviewed earlier of aggravated kidnapping. Now, here's the complicating factor. Mandy Bachman entered an Alford plea. And an Alford plea is a plea in which you acknowledge that the state has enough evidence to convict you of the crimes for which you're charged, but you're contending that you're innocent. So she did so as part of a plea agreement with prosecutors. She allocated in a written statement that was filed with the court to her guilt in the crime. She also stated that she did so knowingly and voluntarily at a hearing, but she later tried to withdraw her Alford plea. Under Rule 11 of the Utah Rules of Criminal Procedure, a defendant may withdraw a guilty plea before sentencing, and Mandy Bachman had not been sentenced before her motion to withdraw her Alford plea that was filed on April 8th, 2025. Now, previously, a defendant could not withdraw their plea under Utah Criminal Code Section 77-13-6 without leave of the court or showing that the defendant did not knowingly or voluntarily enter the plea. This was struck down in State v. Rippey at the end of 2024 by the Utah Supreme Court because it said that that section of the criminal code, Section 77-13-6, violated the separation of powers of the Utah State Constitution. Procedural rules are governed by the judiciary. Substantive rules are governed by the legislature, and the court held that 77-13-6 was intruding into the area of procedure, which is something that is set by the judiciary, so the legislature was overstepping its bounds. So the question of whether Mandy understood the charges against her is central to the issue of whether or not she can withdraw her Alford plea under Rule 11 of the Utah Rules of Criminal Procedure. Now, evidence of her lack of understanding is seen in the shoddy work by Bachman's original attorney, as evidenced in the motion to withdraw a plea and set an evidentiary hearing in which Ms. Bachman's attorney references her as a male and as Mr. Perez. And we're going to see that here in a second in these excerpts. So as this excerpt from the motion by Mandy's attorney makes clear, her attorney did not bother to correct a clear cut and paste motion from a different case, both in terms of pronouns and names. So first off, to enter a valid value, it should read valid plea. Ms. Bachman had to have a full understanding of what the plea connotes and of its consequences. His plea, her plea, would be unconstitutional if the circumstances surrounding it do not comport with the Fifth Amendment due process clause, which requires the plea be an intentional relinquishment or abandonment of a known right or privilege. Among the requirements, Ms. Bachman would have to have knowledge of the nature of the charges, the law in relation to the facts, the critical elements of the offense, and the direct consequences. A proper plea must be a voluntary choice between alternatives. Any waiver of rights by Mr. Perez, not Ms. Bachman, would have been understood by him, regardless of whether or not his name, not her name, appeared on a form typed in his non-native language. Well, Ms. Bachman speaks English, that is her native language, so clearly Ms. Peterson, the original counsel for Ms. Bachman, was using a motion that she typed up for another defendant. She cut and pasted it, and that is indicative of the type of advice or the type of attention to detail she would have offered Mandy Bachman as a defendant and as her client. So again, this goes to the argument of ineffective assistance of counsel. On the next page, what we're going to see is that it might border on incompetence. So her plea would be involuntary, not involuntary, if she was reliant on counsel's advice that was, quote, not within the range of competence demanded of attorneys in criminal cases. So here we have the incorrect use of, or incorrect choice of words, or the incorrect spelling of involuntary. Pick your poison. Either way, it is not a good look for Miss Jessica W. Peterson, who was the attorney for the defendant originally. Ms. Peterson filed her motion to withdraw, which was granted by the court because she is now a witness in this case as it pertains to the issue of withdrawing the Alford plea. So this is the central issue in Mandy's case at the moment. Whether or not her Alford plea was entered based on competent advice from her attorney, or if the contents of that attorney's shoddy work product in this motion to withdraw her plea is indicative of the attorney's advice. Was the attorney equally as sloppy or equally as rushed in giving advice to Mandy that compelled Mandy to enter into the Alford plea, basically plead guilty, when in fact Mandy did not understand the charges against her and could not have understood those charges without competent advice from her attorney. So that's where we're at. She's tried to withdraw her Alford plea, which is effectively a guilty plea. She's acknowledging the state of Utah could have convicted her of the charges against her, even though she contends she was innocent. So what's what's important here is to note that Mandy did not say that she was guilty of any of these charges. She just acknowledged that the evidence was there to convict her under the law, but she contended that she was innocent. This is a little bit different than an outright guilty plea. So now we get to civil rights violations. Mandy Bachman claims that she has been denied medical treatment while she was incarcerated. That is a violation of her constitutional rights. The state of Utah, regardless of what she has allegedly done, cannot violate her constitutional rights by denying her medical treatment for issues that she has. She claims that she has been subjected to threats and intimidation for alleging that elected officials in Goshen were engaged in sex trafficking and ritual abuse, and that she was denied due process and a speedy trial while the state and the court wrangle over her motion to withdraw her original Alford plea. She has alleged that the advice she received from her attorney, which led her to enter her Alford plea, was quote, not within the range of competence demanded of attorneys in criminal cases. That's a direct quote from that motion, which was filed by that attorney, Jessica Peterson. So each of these claims are serious and should be met with public outrage. A violation of one person's rights is a violation of everybody's rights. And so her vigil is Tuesday, August 25th, 2025, or actually August 5th, at 10:30 a.m. in Provo, Utah, at the 4th District Court at 137 North Freedom Blvd.
So I have a question.
Sure.
So when I read the report, it said that Ty and Caitlin and Beth came to Derek's house at 10:30 at night. Is that true? And
Yes.
why would they pick such a late hour?
Because under the facts of the case, as outlined in the filings, these three individuals, Ty Wetton, Beth Chardine, and Caitlin Bachman, originally went to the wrong location. Mr. Derek Morell's previous address at an apartment. They had an encounter with the apartment manager. At that juncture, the apartment manager told them that Mr. Morell no longer lived there, so they eventually did locate Mr. Morell's current address, which was in Vernal. And they then proceeded to travel there at 10 o'clock at night. So that's why things proceeded in that manner. That's why they were there at that late hour.
Well, any official wouldn't be at someone's house that late at night, so that probably told Derek that Ty was not a social worker and he wasn't conducting official business.
That is, if Ty in fact represented himself to be a social worker, and if he did in fact present a forged court order. We don't know. We do know that Beth Chardine has turned state's evidence that she pleaded guilty and that she testified against Mandy Bachman and her co-defendants. She identified Mandy Bachman as the, quote, mastermind and ringleader, that she testified that Mandy manipulated her and the other defendants, that Ty Wetton was crying on his way there. But that Mandy told him that angels would protect him, that Derek Morell would not be able to identify him. That's what Beth Chardine alleges. So as we proceed through this, regardless of whether or not Mandy Bachman is guilty or not, you can't violate her civil rights. And that's what this vigil is about. This vigil is about making sure that she has due process, that she's able to withdraw her Alford plea, and that the state actually has to do its job and prove the allegations against her. This is something that every single one of us is afforded the opportunity before sentencing to withdraw a guilty plea. In the state of Utah, due to the fact that recent precedent has upended the plea withdrawal statute that we referenced earlier, and now Rule 11 alone governs whether or not you may withdraw a plea. In the plain language of Rule 11, you can withdraw a plea before sentencing. You can withdraw a guilty plea. That includes an Alford plea before sentencing. Now, of course, the court does not have to grant your motion to withdraw, but it should not take as long as it has from April to the present for the court to either deny the motion to withdraw or to grant it. I suspect that the court is upset that she is withdrawing her motion or withdrawing her offered plea, A, because it complicates things quite a bit, and B, because in filing the motion to withdraw and requesting an evidentiary hearing, she has preserved this issue for appeal. And so that means that even if the court does deny her motion to withdraw her Alford plea, she has preserved that issue for appeal, and that she can appeal the court's ruling. And so as a means of being punitive and as a means of, compelling her to back off, the court has delayed for a solid 4 months. She withdrew on April 8th. She attempted to withdraw her offered plea, or filed a motion to withdraw her offered plea on April 8th. We are now at August 3rd, and at this hearing on August 5th, it will be 3 days before, 4 months exactly. So what we're looking at is a situation where Mandy Bachman has been incarcerated for the better part of over a year. She has filed a motion to withdraw her original Alfred plea as part of a plea agreement with the state, which she's entitled to do under Rule 11. The court has delayed ruling on this for 4 months. At the end of the day, everyone is entitled to a speedy trial. Everyone's entitled to medical treatment while they're incarcerated, even after you're convicted of a crime. You have a right to medical treatment for any medical issues that you may have. It does appear that the state of Utah is being heavy-handed with her, not just for the crimes that she is accused of, but because previously she accused elected officials in Goshen of being engaged in sex trafficking and ritual abuse. And as part of those issues, she alleges that she was harassed and intimidated by law enforcement in Goshen and in Uinta County and elsewhere. So she's had a long and acrimonious relationship with law enforcement and the criminal justice system across multiple counties and locations for almost 2 years now, as it pertains to her daughter Lindsay's divorce from Derek Morrell, and as it pertains to the custody of Piper Morrell, who was removed from the custody of Lindsay, who was living with her mother Mandy in Goshen at the time. So what we have is a custody situation gone awry for any number of reasons. However, that does not justify or warrant the violation of civil rights for Mandy Bachman. It doesn't justify the state slow walking her case. And so, as a result, investigations of ritual abuse and Relentless Hope will be present at the August 25th, or August 5th, 2025. The flyer said the 25th. It had a typo on the date. August 5th, 2025 at 10:30 a.m. at Freedom Boulevard at the Provo District Courthouse. We'll be there to support Mandy Bachman as it pertains to her civil rights violations. Issues such as ineffective assistance of counsel, the withdrawal of the Alfred plea, as well as the alleged denial of medical treatment. These are things that warrant public outrage and public support for Mandy Bachman. Now, I'll be the first one to tell you that if Mandy Bachman did in fact enlist these people to commit felonies, she should be tried and convicted, and she should face punishment up to and including incarceration for this. However, the state still has to prove that, and the state should not be able to use a slow-walked judicial process to compel Mandy Bachman or any other defendant to plead guilty to a crime. And unfortunately, in our system of justice, or injustice as I like to call it, a lot of defendants face the prospects of this, and a lot of defendants face the prospect of this. One of the things that's lost in the debate over this is the right to a speedy trial is not merely afforded to defendants or alleged perpetrators, it's also afforded to victims. And so the longer this continues, you're not just violating the rights of Amanda Bachman, you're also potentially violating the rights of Derek and Piper Morrell. And it's in everyone's interest, including the public, to have these issues addressed expeditiously justly and constitutionally in order to ensure that everyone's rights are respected.
So I'd like to add to that. I spoke with Kim Bachman, Mandy Bachman's husband. He has stood by her and supported her during this entire time, and I asked him, how is she doing? Mandy, the reason why this is so important that we get this case going is because Mandy has been malnourished. She's not getting the proper diet. She's not getting the food. She has food sensitivities. They're not modifying her diet. She is now down to 80 to 90 pounds. Her once healthy brown hair has turned white. The stress is really getting to her. Kim Bachman asks for your prayers and your support. He had also mentioned that she now has a new counselor, a new lawyer.
A new lawyer, yes.
However, that new lawyer doesn't seem to be really working for Mandy and helping her in this situation. So Kim has asked that you contact the judge in this case, try to persuade him to withdraw the original plea deal, right? And allow her to post a new plea. Is that exactly?
Apparently she intends to plead not guilty.
Okay.
And of course at that point the state would have to do its job and prove beyond a reasonable doubt that she committed these crimes. The state may do that. For obvious reasons, the state does not want a trial when they could have a plea that would shorten the process for them and also enable them to just proceed to sentencing. So one of the things I would tell anybody out there who's facing a criminal charge, make the state do its job.
Mm-hmm.
Don't take the plea. Make your attorney do their job. It's unfortunate that in our system of justice, that defendants sometimes find themselves being railroaded into plea agreements that they don't fully understand, that with consequences that they don't fully understand because their attorneys did not explain it to them. Apparently that was the case with Mandy's ongoing legal issues as it pertains to these charges. Now, to be fair, she also has another separate case involving alleged extortion and bribery down in Goshen. So the other thing that I would caution people is when you find yourself in a situation where you feel like you have no other choice, you do. Always consult with an attorney. Always look at what the criminal code actually says before you make a decision or a choice. And be very careful about how you proceed with other people in terms of your communications with them, in terms of the claims that you make about them, and in terms of the acts that you undertake towards others. Even though you may feel that you're right, even though you may feel like you have a justification for acting a certain way, the truth is you will bear the consequences of your actions legally and criminally and civilly. You have any closing thoughts?
Yeah, I do actually. I want to give credit where credit is due, because the person who organized this prayer vigil is Buffy Snell, and she is the leader of Warrior Women, who is a group of survivors. They communicate via Telegram, and I asked her, I'm like, how did you come about this case? And so I'm just going to read directly from her comments. She said she got actively involved when they held a hearing for David Hamlin's case in Manti and started attending events that were related to SRA, child trafficking, and exposing those involved. And so she believes that some of the same people in charge of prosecuting these kinds of crimes are also the same ones committing them. So what do citizens do? The reason she wanted to help too is she said, I firstly wanted to help because I believed Mandy. After a lot of study and interviewing those close to the case, I believe she has been wrongfully charged and mistreated for exposing those who participate and support the sexual abuse and trafficking of children. The second reason that she said Mandy reported an alleged pedophile and her ward boundaries to her local religious leaders, a bishop and a stake president, and later another higher authority. All 3 times these men allegedly dismissed Mandy's concerns and pleas for assistance. So we just want to thank Mandy for bringing this case to our attention. Again, I'm just going to reinstate, she is asking everyone to show up in mass to the vigil on Tuesday, August 5th. It starts at 10:30. It's located at the 4th District Court in Provo at 137 North Freedom Blvd. We're going to add this to the show notes below, and also check our website at relentlesshope4u.org. Please wear blue, Buffy says. That's Mandy's favorite color, and bring signs and flags. And we're gonna have powerful speakers, prayers, music, and in addition to that, she said prior to the vigil there will be a hearing for Mandy at 9 a.m. at the 8th
Judicial District.
Thank you. In Vernal, Utah. You can attend this virtually via WebEx, and you'll want to request a WebEx link by calling the courthouse at 435-264-4560. So thank you, Buffy Snell.
This is Jay Darcy for Investigations and Ritual Abuse, and
This is Cindy Metcalf Darcy from Relentless Hope. Thank you for joining us.
we will see you the next episode. We hope to see you on Tuesday, actually.